The media is very important to our concept of open justice, and open justice is vital to the implementation of the rule of law, because we expect people in our community to know what their obligations are. It's not the expectation that everyone's going to be a lawyer, but we have rules that we must follow, and those rules must be defined and must be able to be known. And one way that we can have those rules known within the community is by having an education as to what occurs in the courtroom, where laws are being applied, where consequences of breaches of law are then applied. The media occupy a role of being able to disseminate that education within the community, and it's also a part of the rule of law in allowing people to participate in the practice of law or the implementation of law. For example, when we have jurors come into our courtrooms in criminal trials, that's part of that participation. The media is another part of that open court system and the participation of the community, and in turn the education of the community. I haven't encountered really many problems at all. Occasionally there is some inaccuracy in reporting, and most media outlets are very quick to correct inaccuracies where that's pointed out. In the district court, for example, we have a media liaison officer, and that person has the role of facilitating the accurate access to information. So I haven't really encountered problems in that regard, but I think that that's because there's a good response by most of our media representatives. They are interested in accurate reporting, and it's vital that they maintain that practice. To arrive at the sentencing outcome is often a complicated exercise, and there's a reason why people have a great deal of background in criminal law before being able to undertake that role. It's a process of instinctive synthesis. That's the term the High Court has applied to the role of a sentencing judge in arriving at the appropriate outcome, and there are many different matters that must be taken into account. Section 3A of the Crime Sentencing Procedure Act for the New South Wales legislation provides an exhaustive list of sentencing purposes, such as to denounce the crime, to make the offender accountable, to promote the rehabilitation of the offender, to recognise the harm done to the victim, and to deter other people and the offender from committing these crimes in the future. Some of those sentencing purposes in any given case can pull in different directions. So the instinctive synthesis is being able to recognise those features, understand how the evidence adds emphasis or weight to any of those sentencing purposes, and then to arrive at a just and fair outcome. Now, the challenge is in how all of those sometimes competing purposes might come together in a balanced result. It has happened infrequently, but I must hasten to add I'm a great fan of the jury system, because in my view that's a real opportunity for the community to participate in the process of our criminal law. When I said earlier the media is one way that the community can participate, by that what I meant is in terms of the media being able to publish what is occurring in the courtrooms. But for the jury, they take the place of the tribunal of fact, so they have that direct engagement. And when each and every one of those jurors goes home, they, no doubt after the trial has finished, speak of the law and the operation of law, and it's important that that message gets through to the community. Where a jury has brought in a verdict with which I have some disagreement. I think that's the strength of our jury system, because each of those jurors is a representative of the community. Because they're selected at random from our community, one can almost guarantee that there will be a diversity within that jury room. And that's a robust jury, where you have a representative jury of the community. So when a jury does bring in a verdict with which I have some surprise, that's not to say that that disheartens me in any way, because that is the verdict of the community. In sentencing an offender where there has been a jury verdict that has been of some surprise, the challenge can be then for the sentencing judge to find the facts for the sentencing exercise. Because when a jury delivers a verdict, the jury is not obliged, and in fact they don't, give reasons for their verdict. Whereas when a matter proceeds by way of a judge alone trial or in the local court before a magistrate, full reasons are to be given for all the findings of fact and why that then amounts to proof by the prosecution beyond reasonable doubt of the guilt of the accused. But a jury simply announces guilty or not guilty where they bring in a verdict. So the challenging aspect can be, after a verdict that doesn't quite meet what I was expecting, that I then need to be able to find the sentencing facts consistently with the verdict delivered by the jury. But judges and magistrates, all when being appointed to these positions, give a promise to apply the law without fear or favour. So the verdict of the jury is the verdict of the court.